Hi, I'm Patrick McNamara. Since 1994, I've had the privilege to represent NAFS as your general counsel. Unfortunately, this year we faced the disappointment of not being able to meet in Longboat Key Resort. And I'm not coming to you from the Hard Rock Cafe, but actually one of our conference rooms in our main office in Lyndhurst, New Jersey. One of my colleagues, Ron Beanstalk, specializes in doing intellectual property and in particular representing companies in the entertainment industry. So we always like to showcase what we call Hard Rock Cafe Lyndhurst. So with that, let me turn to my annual presentation. Before I do, I want to thank the convention committee for extending the invite for me to participate again this year. It's been a privilege for me now to appear at the convention for over 25 years, and hopefully with many more to come, including next October. The FDA has investigated a series of outbreaks over the last year about various bacterial outbreaks in the food chain. In August of 2020, there was an investigation of an outbreak of salmonella in peaches packed or supplied by Priam of Wawa-Ona Packing Company in late August. Initial reports were up to close to 80 cases across 12 states. In June, there was an investigation of Fresh Express bagged iceberg lettuce, red cabbage, and carrots that were sold in several regions of the United States due to an outbreak of Cyclospora. Fresh Express products were sold in places such as Walmart, ShopRite, Giant Eagle, and Aldi. In July, there was an outbreak of salmonella investigated in red onions from Thompson International. In response, on August 1st, Thompson recalled all varieties of onions that could have come in contact with potentially contaminated red onions due to the risk of cross-contamination. They were sold under the brand labels of Thompson Premium, TLC Thompson International, Tender Loving Care, Imperial Fresh, Kroger, and Food Lion, amongst others. As was recently reported in confectionery news, a number of manufacturers, including Mars Wrigley and Barry Callebaut, have released and made available their interactive maps, putting out data on where they source their cocoa. It was reported this ongoing effort in response to government inquiries about the need to preserve certain forest areas from additional farming while trying to balance the need to maintain a sustainable supply of cocoa. In June, GNC filed for bankruptcy protection under Chapter 11 of the federal bankruptcy laws. Since the initiation of that filing, Harbin Pharmaceutical Group was serving as the proverbial stalking horse, looking to bid for acquisition of the company, since they'd already invested over $3 million into GNC prior to the bankruptcy filing. The filing with the Securities and Exchange Commission, GNC stated that the proposed bid from Harbin had been accepted by the Debtors Committee on August 7th and was approved by the Bankruptcy Court on August 19th. The notice of auction cancellation was then filed with the Bankruptcy Court on September 14th, noting that the only qualified bid came from Harbin. The court is now scheduling a conference. This is being held in the U.S. Bankruptcy Court for the District of Delaware to hear any objections and potentially approve the sale to Harbin. In the filing with the SEC, GNC stated that they hoped that the auction could be completed and the sale of assets performed to allow GNC to emerge from Chapter 11 proceedings before the end of the year. Smithfield Foods has announced that it's challenging the issuance of a citation from OSHA where the potential penalty is just over $13,000 for alleged violations of safety guidelines at its Sioux Falls, South Dakota plant prior to March 23rd of this year. It also is contesting that OSHA failed to issue an official guideline for the meatpacking industry, leaving companies to work at what they should be doing on their own. Smithfield asserts in its own words, quote, "We took extraordinary measures on our own initiative to keep our employees as healthy and safe as possible so that we could fulfill our obligation to the American people and maintain the food supply." The company claims it has invested over $350 million during 2020 with regard to implementing various safety measures at its facilities. The North American Meat Institute took sides with Smithfield in this case, stating in a press release that when the pandemic hit, quote, "Meat and poultry processing companies quickly and diligently took steps to protect their workers," close quote. In sharp contrast, the United Food and Commercial Workers Union, which represents over 1.3 million workers in meatpacking plants and other related businesses across the country, attacked the proposed fine as being, in their words, quote, completely insufficient in the wake of the company's failure to protect meatpacking workers in its Sioux Falls, South Dakota facility, which reported nearly 1,300 COVID-19 infections and at least 4 deaths. Various food, retail, and trade associations have been taking sides in the fight, claiming that Smithfield Foods and related trail groups are supporting their initiative, while health advocacy groups like the Center on the Science and Public Interest believe that there should be not any type of liability shields from companies who have not done what they consider proper steps or have engaged in what they consider negligent conduct. They may be aware of protections for companies that may face COVID-related lawsuits, period. One of the running disputes in the pending legislation for the latest code of relief package in the House and the Senate has been whether or not there should be liability shields enacted to protect companies that still had workers on the job site who may have been exposed or actually contracted the COVID virus. The law firm of Midler Lendison has been keeping track of how much litigation has been brought against certain industries. So far, they have tracked over 600 lawsuits, including 72 class actions, filed against various companies due to alleged labor and employment violations related to the coronavirus since mid-March. With the absence of additional federal standards or CDC guidelines, it's going to be up to each state to make its own determination, even down to the county or municipal level, as to the amount of trick-or-treating and Halloween festivities that will be permitted given the current pandemic. The Confectioners Association, on its Halloween Central website, is promoting various types of what they consider safe activities during Halloween celebrations. The recent court ruling in Pennsylvania invalidating some of the shutdown orders that had been issued by their governor as being unconstitutional will now have governments at all levels looking closely at their policies to determine what they believe can continue to be imposed to protect public safety during Halloween festivities that will not run afoul of threats of litigation over infringement of constitutional rights of freedom of association and freedom of speech. Morris Wrigley has announced that it's launched its digital treat town, say that 3 times fast, to provide a virtual trick-or-treating experience for those unable to go door-to-door this year. On August 21st, the U.S. FDA issued interim file rules regulating the use of hemp. Issuance of these regulations was mandated under the Agricultural Improvement Act of 2018, more commonly known as the 2018 Farm Bill, which legalized hemp under federal law. The proposed regulations will have a significant impact on the hemp industry and are likely to be subject to extensive public comment. The DEA is amending its regulations on marijuana under the Controlled Dangerous Substances Act, where hemp is also being removed. The DEA interim final rule also emphasizes that the definition of hemp does not automatically approve any product derived from hemp plants, regardless of the amount of THC or CBD content of the derivative. In order to meet this definition of hemp and thus qualify to be exempt from Schedule 1 and being regulated as a controlled dangerous substance, the derivative must not exceed the 0.3% threshold. Comments must be submitted either electronically or postmarked on or before October 20, 2020. It is not known at this time as to whether the DEA will extend the comment period beyond this deadline. You'll find enclosed with our materials a copy of an article authored by my colleague Dan McKillop, which summarizes in greater detail the proposed rule issued by the DCA, and it's also available on our law firm website. Several lawsuits have been filed in federal court in Broward County, Florida, by the U.S. FDA alleging PetSmart claimed that it was using false and deceptive advertising for selling hemp products for pets that had not been approved by the Food and Drug Administration. The lawsuit has been filed by 2 individual customers, but the plaintiff's counsel are seeking class action status. The lawsuits allege that the customers purchased products from PetSmart that were marketed as intended to treat, mitigate, or prevent disease, provide calming stress and anxiety relief for dogs. The lawsuit alleges that the products failed to measure up in the pleading, quote, to their expectations thus created by the defendant, close quote. Both lawsuits claim that because the FDA has not approved these products, they are considered unsafe and cannot be lawfully sold. The lawsuits are seeking compensatory and punitive damages to be determined at trial, and the issuance of an order prohibiting PetSmart from continuing to sell these products. Both lawsuit pleadings are available online through the court system for Broward County. A lawsuit that had been filed in federal court in California challenging the labeling of Bare Naked granola vanilla products was thrown out by Judge Roger Benitez. The court found that the plaintiffs had failed to provide adequate proof to support the allegation and could not say where the vanilla flavor had originated from. The court said that the plaintiffs made only two blind factual allegations: that the product was not flavored with vanilla flavoring derived exclusively from vanilla beans. The court opined that, in its words, plaintiff alleged the product does not contain vanilla flavoring derived exclusively from vanilla beans, but provides no factual basis for this argument and lacks any proof of vanilla inclusion on the ingredients list to be challenged. The court also noted that the plaintiff's class action lawsuit failed to allege a violation of FDA regulations and thus failed to state a cause of action. The plaintiffs alleged that he had relied upon various illustrations and representations on the packaging, including the use of the word V'(Nilla) on the front and the back of the package. He claimed that as a result he was being overcharged for the product and that Kellogg had obtained wrongful profits, period. On August 9th, a class action lawsuit was filed against Hostess Brands, alleging that the company had deceptively marketed its products as a carrot cake donut, when in fact the allegation was it contained no real carrots. The lawsuit was filed in the U.S. District Court for the Southern District of New York as a class action complaint by the law firm of Spencer Sheehan, which has a history of supporting this type of litigation. The complaint alleges that the representations by Hostess in the complaint's pleading are, quote, misleading because the product contains less carrots than consumers expect and contains no real carrots. The complaint goes on to allege that the marketing being used by Hostess would mislead consumers. Allegations were also made in the complaint that Hostess is in violation of the New York General Business Law, consumer protection statutes, negligent misrepresentation, breach of express warranty and implied warranty of merchantability, and the Magnuson-Moss Warranty Act. In addition to seeking class action certification, they demand an order by way of injunctive relief, directing the defendant to correct all of its allegedly abusive advertising practices, and awarding not only compensatory and punitive damages, but legal fees as well. In another class action lawsuit, Ocean Spray agreed to pay $5.4 million to resolve claims in a class action case that some of their juices were falsely advertised as containing, quote, no artificial flavors. The settlement group benefits people who may have purchased certain Ocean Spray products between January 1 of 2011 and January 31 of 2020. The lawsuit had been filed in November of 2017 as a class action, where the allegations had been that the company wrongfully represented their products as containing no high fructose corn syrup, artificial colors, or flavors. Industry groups filed a series of lawsuits seeking to overturn ordinances adopted in the City of Los Angeles, Edmond, Minnesota, and the City Council of Philadelphia, which tried to prohibit the sale of menthol cigarettes, flavored smokeless tobacco, flavored cigars, pipe tobacco, and flavored e-cigarette product. The lawsuits were venued in federal court in each of these states, and one of them, the plaintiffs were usually R.J. Reynolds, American Snuff Company, and Santa Fe Natural Tobacco Company. The lawsuit centered in California claimed that federal law, specifically the Family Smoking Prevention Tobacco Control Act, prohibited state and local government from adopting these types of ordinances. Claims asserted in the lawsuit filed in the federal court in the District of Minnesota made the same basic assertions as the one filed in California. Subsequently, a federal district judge in the Central District of California dismissed the lawsuit against the ordinance. In a ruling issued on August 7, Judge Dale Fisher ruled that the ban did not interfere or violate the Federal Facilities Smoking Prevention and Tobacco Control Act. The court held that the ban enabled in the ordinance was consistent with federal law, regarding the regulation of tobacco products. It will be interesting now to see how much precedential value this case will be given in the other lawsuits pending in Minnesota and Pennsylvania, and whether more ordinances of this nature are going to be drafted and approved by various municipalities. In contrast, the lawsuit filed in Philadelphia was brought by the Cigar Association of America, ITG Cigars, Swisher International, and Swedish Match of America. This lawsuit not only asserted certain federal claims, but also argued that state law prohibited such ordinances by local governments to regulate the sale of tobacco products in Pennsylvania. At last year's convention, I mentioned the lawsuit had been filed in the U.S. District Court in New York in October of 2019 against Wegmans, seeking class action status of food fraud of vanilla ice cream without selling the product with the actual vanilla flavor in it. Once again, the lawsuit was filed by Spencer Sheehan of New York. In a ruling issued on July 14th, 2020, the federal judge dismissed the case against Wegmans, saying that the alleged deceptive practices did not exist. Judge Lewis Stanton dismissed the claims after determining that the analysis provided by the plaintiffs may not have been sensitive enough to detect the markers of vanilla, and as such could not prove that vanilla was not in the product. The judge also questioned in his decision whether the labeling was actually deceptive, since neither the label nor ingredients state that the ice cream uses vanilla bean or vanilla bean extract. The plaintiffs had claimed that the grocery chain violated New York consumer protection laws by deceiving them into thinking the ice cream was flavored with vanilla beans or vanilla bean extract, even though most of the vanilla flavor came from other types of sources. There have been a recent spike in these types of lawsuits being filed in New York over the last couple of years, to the point where the number of lawsuits related to the flavoring industry has almost matched the number of lawsuits filed annually in California. On September 15th, the FDA announced that Fortune Food Products of Illinois, a processor of sprouts and soy products, had agreed to cease production until it undertook general remediation action to comply with the Federal Food, Drug, and Cosmetic Act. The actions are the first consent decree of permanent injunction against a grower for violating public safety standards under the produce safety rules enacted under the Food Safety Modernization Act of 2011. This action was taken after several inspections had been conducted by the FDA, who found that the company failed to comply with produce safety and good manufacturing practice regulations. This action follows a prior warning notice that had been sent in July of 2018 by FDA, outlining a series of food safety violations. The injunction was entered by U.S. Federal Judge John Blakely for the U.S. District Court of Northern Illinois. The consent decree prohibits the company from growing, harvesting, packing, and holding sprouts and soy products at or from their facility or any other facility they operate until certain requirements are met in terms of various corrective actions, and the FDA must be notified before any operations resume at the facility. On September 9th, Food and Drug Administration, in partnership with the CDC, released new data from a 2020 National Youth Tobacco Survey. It showed approximately 1.8 million fewer U.S. youth are currently using e-cigarettes compared to 2019. This was taken as good news following 2 years of significant increases in such uses among youth. The report was tempered with the acknowledgement that over 3.5 million youth are currently using e-cigarettes, which the agency described in its words, quote, a public health crisis that is affecting children, families, schools, and communities. The announcement also coincided with a deadline for the submission of tobacco product applications on the market as of August 8, 2016, were required to be submitted to the FDA by September 9, 2020. Any company that did not submit prior to the deadline who wishes to introduce a new product into the marketplace must now submit a pre-market application and receive authorization from the FDA before doing so. The FDA has set up a dedicated page on its website for information for potential registrants. On September 9th, the U.S. Department of Agriculture announced that it was modernizing its inspection methods for egg production since the first time the Egg Products Inspection Act was adopted nearly 50 years ago. The intent of the rulemaking is to align the egg product inspection regulations to be consistent were current requirements in the meat and poultry product inspection process. Under the new rule, federally inspected egg product plants are required to develop and implement HACCP systems and sanitation standard operating procedures. The U.S. government has said it will continue to test for salmonella and listeria contamination in egg products. Under this system, plants should be able to tailor a food safety system that best fits their particular facility and manufacturing equipment. The agency announced that under the Food Safety Inspection Service, it will be assuming regulatory authority over egg substitutes and freeze-dried egg products, which compose the same risk as egg products for contamination. They will be inspected in the same manner. The new regulations also govern the importation and inspection of foreign egg products more closely with the regulations matching up again to foreign meat and poultry products that are inspected by the agency. A list of the new regulations can be downloaded at www.fsis.usda.gov. On August 28th, the Federal Trade Commission issued an administrative complaint which alleged that Altria Group and Juul Labs had entered into a series of agreements, including Altria's acquisition of a 35% stake in Juul, that eliminated competition and violated federal antitrust laws. According to the complaint in a press release issued by the FTC, the series of alleged agreements involved Altria ceasing to compete in the U.S. market for closed-system electronic cigarettes in return for a substantial ownership interest in Juul, which the agency deems, in its words, the dominant player in its market. This is the latest in a series of steps that have been taken dating back to April 1st when the FTC filed litigation in an attempt to unwind Altria's $12.8 billion investment in Juul. In remarks recently given during the 2020 Dietary Supplements Regulatory Summit, Stephen Tate, who is the director of FDA's Office of Dietary Supplements Program, discussed the problem of what he defined as a regulatory gap, which he defined as the space that exists between what the Dietary Supplements Health and Education Law Act of 1984 requires and what can be reached through realistic expectations of enforcement. In his remarks, he stated, quote, "We can't responsibly ignore the regulatory gap or pretend it's not there. That's not in anyone's interest, consumers, responsible industry members, or regulators. All concerned should be demanding a better regulatory dietary supplement market. It's share a duty to identify and pursue ways to narrow the regulatory gap." In his remarks, he acknowledged dietary supplements may not be subject to the same level of regulation as other FDA-related products, but he said the dietary supplement market may not be well regulated. All he can say is that it's not perfectly regulated. The state of Oklahoma recently adopted what is popularly known as the Oklahoma Meat Consumer Protection Act, and it's scheduled to take effect on November 1. The act, which was signed into law in May, is designed to restrict various types of labeling on plant-based meat alternatives. Principal sponsor of the law, State Senator Michael Bergstrom, stated that this legislation ensures that clarity and accuracy of labeling meat in plant-based food items gives consumers peace of mind that they are purchasing exactly what they intended. A lawsuit has been filed by Upton Naturals and the Plant-Based Foods Association challenging the enactment of this law. The law requires that the fine print in the labeling of these products stipulate that it includes a disclaimer stating the products are derived from plant-based sources and that the labeling has to be in a size of type that is uniform in size and prominent to the name of the product. Daniel Stockman, who is the founder of Upton Naturals, claimed that, quote, "Our labels make it perfectly clear that our food is 100% vegan." The Institute of Justice, which is weighing in on the side of the Plant-Based Food Association, noted that the state of Oklahoma already has laws prohibiting the use of misleading labels on food products. Legal counsel asserted that, quote, "Since the meat industry couldn't use that law to thwart honest competition, they encouraged the legislature to pass a new one. The First Amendment does not allow the government to compel speech just to protect special interest groups from competition." The plaintiffs are also seeking an injunction to prohibit the state of Oklahoma from enforcing the law while the case is still being litigated. The action was filed in the U.S. District Court for the Western District of Oklahoma on September 16th. On September 20th, the Health and Human Services Agency issued a memo on agency procedures, which now mandates that before regulations are issued by any agency, including the FDA and others, under the umbrella of HHS, must now carry the personal signature of the Secretary of HHS. Reaction to this has been mixed, with regulatory companies saying that this is nothing new and is only a manner of implementing what already is law, but yet others feel that this is an overreach and is unduly interfering with the functions of issuing regulations by various agencies, including the FDA. They claim that before the issuance of the memo, the process required all rules to get White House clearance anyway, so that this is now just one ministerial act rather than a change in the entire regulatory process. The FDA recently announced a proposed rule to establish additional traceability record-keeping requirements for certain foods. The FDA has also published a draft food traceability list, which describes the foods that would be subject to these proposed requirements. The list includes, among other products, leafy greens, fresh-cut fruits and vegetables, various types of fish, shell eggs, and nut butters. The proposed rule has been published in the Federal Register, and comments are due within 120 days of that date of publication. Comments can be submitted both in written form and electronic form. The proposed rule is captioned "Requirements for Additional Traceability Records for Certain Foods," and is considered a key component of the FDA's new era of Smarter Food Safety Blueprint, and would implement Section 204D of the FDA Food Safety Modernization Act. If finalized, the proposal will establish and standardize the data elements and information firms must establish and maintain, and the information they would need to send to the next entity in the supply chain to facilitate rapid and accurate traceability. If you'd like more information about this, you should speak with Bob Bauer, since he's been heavily engaged in Food Safety Modernization Act's issues on behalf of the Association of Food Industries. With that, let me conclude my remarks. If anyone has any questions they'd like to ask me, I'm told there will be a chat feature as part of the virtual broadcast of the convention this year. You can also submit questions to either Bob Bauer or Aaron Jordan at NAFS, and I'm sure they'll relay them to me so I can respond to you. Again, it's been my privilege to represent NAFS for over 25 years, and I'm very grateful for the opportunity to continue to serve and to be a part of this convention. Thank you.